A sheriff in Wisconsin has threatened to arrest a 16-year-old girl and her parents if she didn't delete an Instagram post talking factually about her medical condition, trying to warn other people who have been in contact with her that she might have actually had coronavirus. Let's talk about how ridiculous this is. Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. And today we're talking about a sheriff in Wisconsin who demanded a teenage girl take down her Instagram post in which she says she'd gotten over COVID while she and her parents were trying to alert everybody that she might have had COVID. And I guess the sheriffs didn't want that to happen, ignoring the fact that you have a free speech right to say pretty much all of this and to participate in a public debate about public health. Yes, you can do that. But what happens when a sheriff comes knocking at your door and says, delete your post or you go to jail? And that, they're not even denying it. Let's take a look at the suit. I've highlighted the relevant sections. Look, if you like these quick legal takes, go ahead and like and subscribe and all of that stuff. If you want longer things and longer discussions, we do live streams pretty much every weekday at 11 p.m., including tonight, which is Friday, April 17th. But yeah, come check them out. All right, here we go. So this is Amaya Kohun suing now Joseph Konrath, who's the sheriff of Marquette County, Wisconsin, and Cameron Klump, who's a patrol sergeant with the sheriff's department. Yes, Sergeant Klump came to the door demanding a teenager take down her Instagram post. Very, very weird circumstances. Now, we're not going to go through all of this because I want to keep this short, but I'll be following along this case and we may do a full breakdown of it. But this is what's called a 1983 case, okay? That's when someone acting under what's called color of law, like, you know, a police officer in uniform knocking at your door saying there will be legal penalties if you don't do something, that's acting under color of law, infringes upon your protected rights. In this case, specifically, First Amendment rights of speech and association. They can't actually do that. You can't make protected activity unlawful because you don't like it. And we're going to get to some really bad legal takes throughout this thing. But let's start going through this thing quickly. Here's the intro, and this lays out kind of the case pretty succinctly. First Amendment's protection of speech, especially online speech, is as vital as ever during the ongoing pandemic. The unprecedented stay-at-home orders throughout the nation have made social media one of the few outlets people have to communicate with friends and family. This case is about preserving the right to share our experiences with each other during this difficult time. A high school student who had a scare with COVID-19 posted about her experience on Instagram, and a few days later, a deputy sheriff showed up at her home and demanded that she remove her post or be cited for disorderly conduct, arrested, and jailed. And what they don't say here, but they say later, not just her parents. The offending post, a picture of the student, while she was hospitalized for what doctors told her was likely COVID-19, with the caption, "I'm still on breathing treatment, but have beaten the coronavirus. Stay home and be safe." The sheriff's actions blatantly violated the First Amendment. Plaintiff is entitled to recognition of that fact. So there are a bunch of different statutes that entitle you, this is a federal case because this is someone suing their local government, in this case a county sheriff's department, for violation of their federally protected rights. And the cause of action, like I said, it's called a 1983 claim because it's section 1983. And there are other sections, though, that entitle you to a declaratory and injunctive relief. That means that the court says, this is wrong. And then injunctive relief is the court saying to the sheriff's department, stop it, get help. And then they're also, under 1983, entitled to damages. And then there's another section, 1988, which entitles them to attorney's fees and costs. And that's something important to remember here because that's what allows you to bring these suits. Otherwise, you wouldn't be able to. They would cost you know, potentially like $100,000. And what damage did you suffer monetarily that the court can provide compensation for is a tough question. So now though, not only is the sheriff's department, and wait till you see what the family asked the sheriff's department to do that the sheriff's department has turned down. So not only though, now are they going to just say, yeah, we're fine with infringing on their rights. They're going to pay potentially hundreds of thousands of dollars to defend these two officers' clearly unlawful actions. And then they're probably going to end up paying the fees of the child and her parents as well, their attorney's fees. So we've got Wisconsin sheriff, who's right below me here, that guy. He is turning this into a $250,000 to $500,000 problem for Marquette County. Something that, when you see what they ask for, it's embarrassing that they won't do it. It's also incorrect. Look, I'm skipping most of this stuff, but this is, like I said, so it has authority to award damages and issue injunctive relief pursuant to 42 USC 1983. It has authority to award attorney's fees and costs pursuant to 42 USC 1988. USC is United States Code. So if you want to actually look up these laws, you can. You just go into Google, type in 42 USC 1983 or 1988, and it'll pull you up. Usually Cornell Law has a webpage that you'll be able to read the statutes there. The relevant sections are going to be cited in the document here. So Amaya Cahoon is a sophomore at Westfield Area High School in Westfield, Wisconsin. We're not going to go through all of the jurisdictional arguments, again, for time. 4 or 5 days after she returned from Florida, she began feeling ill. Her symptoms included a fever and dry cough, which is consistent with COVID-19. The doctors there at the hospital evaluated Amaya and concluded that her symptoms matched those of COVID-19, but they could not test her due to criteria at the time. So remember, this is shortly, so this is March 22nd, which is shortly after Wisconsin and Florida issued their emergency orders, which was on March 15th. That's covered here in the document. But so this is just 7 days after, and especially back then, testing was really, really hard to come by, except for people who were dying. And she's having fever and a dry cough, but she's not dying at the time. So they sent her home with an inhaler and instructions to quarantine. The discharge order, a true and accurate copy of which is attached here too as Exhibit 1, diagnosed Amaya with an acute upper respiratory infection, unspecified, because they couldn't test for the coronavirus. Doctors also gave the Cahoons a work release form, true and accurate copy is attached, specifying that Amaya has symptoms consistent with COVID-19. So based on the information supplied by the doctors, Amaya and her parents believed and still believe the symptoms were caused by COVID-19. So later she goes on Instagram, she posts, "Hey guys, sorry I've been on a long break. I won't be back for a while longer due to me now having the COVID virus. I don't want the attention, it's just the truth. I'm now in self-quarantine and am not allowed to leave my room and have an inhaler since they said to go home. Best of wishes, love you guys." So she's telling her friends, hey, I'm locked down, I'm on self-quarantine, and that's how that is. So then her symptoms get worse, and she goes back to the hospital and is then transported to Wisconsin Children's Hospital. So she was finally tested for COVID on the evening of March 25th and received the results the following morning. The test came back negative, but the doctors told the Cahoons that Amaya still likely had COVID-19 and had missed the window for testing positive. And then they cite to a paper about the accuracy of COVID tests, citing the study saying as much as 1 in 3 people get a false negative when they had a positive due to the testing window. So Amaya returned home from the hospital in Madison on March 26th. At the time, Amaya and her parents continued to believe, and they still believe, that her symptoms were caused by COVID-19. After she returned home, she posted again to Instagram, this time a picture of herself at the hospital with an oxygen mask on her face. The caption on this post read, "I'm finally home after being hospitalized for a day and a half. I'm still on breathing treatment, but have beaten the coronavirus. Stay home and be safe." All right. So the worst thing at this point that she could possibly be guilty of is being incorrect about something based on what her doctors have allegedly told her. The doctor said, look, test says no. We think you probably had it. And I actually know people who have talked to doctors who've said, you know, based on the symptoms, the timing, you probably had it and got over it. So that's cool. This is even more. This is even more than that. This is her going to a hospital and the hospital telling her you probably had coronavirus, but the testing isn't going to show it because of the timing. So here we get the intervention of the sheriff. The sheriff's deputy Klump. Sergeant Klump stated that he had direct orders from Sheriff Konrath to demand that Amaya delete the post, and if she did not, to cite Amaya and or her parents for disorderly conduct and to start taking people to jail. Sergeant Klump's incident report, a true and accurate copy of which is attached here to as Exhibit 6, confirms defendant's unlawful actions. Klump's report explains that Sheriff Konrath advised me he wished me to respond to the residents and have the post removed from her social media. The report also states that Klump advised Richard Cohoon that if they were not willing to take the post down, that there would be possibility of a county ordinance disorderly conduct or being arrested for disorderly conduct. Klump stated that Konrath wanted the post removed because there were no confirmed cases of COVID-19 in the county at that time. By the way, doesn't matter. Doesn't matter if there are no confirmed cases. Doesn't matter if she's lying about it. Doesn't matter. In a weird way, that doesn't matter that she's lying about it. You can participate in a discussion. Hey, I think I got the coof. I think I got the coof. I just want you guys to know, even if you are lying about it, even if you are doing it for attention, that's your First Amendment right. You're participating in a public discussion about a matter of grave public concern. It's crazy talk here. Sergeant Klump stated that he was not there to gather information, but to complete Sheriff Konrath's orders. That's when the dad said, want to look at our doctor's notes? Want to see what the hospital told us? No. Look, I'm not here to gather information. I'm here to take that post down. Sergeant Klump showed Amaya the screenshot of her post and told her that if she did not remove it, he had orders from the sheriff to begin issuing citations for disorderly conduct and taking people to jail. So, what does she do? She takes it down, right? That's your reasonable, normal person's response. It's just an Instagram post, bro. I guess I can take it down. It's really hard when they're threatening to arrest you, your child, your parents, threatening to arrest your family if you don't take down a post. It's insane. So most people do. They take it down. But that doesn't mean they get away with it. Sheriff Konrath's and Sergeant Klump's threat to cite and arrest Amaya for posting about her experiences are especially troubling in light of Miker's statements, accusing Amaya of not being truthful and engaging in a foolish means to get attention. With threats of law enforcement looming over their head, Amaya has felt unable to respond on social media to Miker's allegations, and she is now afraid of returning to school for fear of what her classmates and teachers will think about her. Miker is associated with the school and put out a statement basically without naming her, saying that it was all a lie. So the school itself has put out a statement calling her stuff a false cry for attention. And again, think of what we're doing here. We've got a government school using a government police force to suppress someone's speech about having coronavirus. And I haven't covered this earlier, but the parents reached out to the school on multiple occasions to say, hey, we think our daughter has coronavirus and we think it might be a good idea if you tell the other parents, because she was on a trip to Disney with a bunch of kids and they could possibly have it too. So you might want to let them know. You know, this is about everybody knowing when they should stay at home and reduce contact to reduce the spread of a virus. You know what the school did? They didn't ever get back to the parents. Instead, they called the police. Disgusting. Absolute trash tier. All of these people should be removed from office. All of them. All of them. Think about what they've done. Not only did they disrespect the Constitution, they literally put others in jeopardy. The entire state in jeopardy. By not informing people about what was going on. Sheriff Konrath declined to acknowledge the First Amendment violation or to provide any assurance that Amaya Amaya and her parents will not be cited, arrested, or jailed for future similar speech about her experiences with COVID-19. Instead, Sheriff Konrath stated that Amaya's speech was not protected by the First Amendment, but was the equivalent of screaming fire in a crowded movie theater. A friend of mine put it this way. This is the angriest lawyer, Grand Admiral C. He says, basically, I'm summarizing. If you have a fire marshal saying, with reasonable certainty, we have a fire in this crowded theater, and then you shout, there's a fire in a crowded theater, you're justified in doing that. You've relied on an expert who is there looking at the thing and determining that there's a fire. At that point, you actually can scream fire in a crowded movie theater. But let's briefly address this. Screaming fire in a crowded movie theater is not actually not protected speech. That is not the ruling in that case. That was dicta in a case. Dicta is the other stuff involved in a case where a judge gets to expound upon his thoughts that are maybe related to it. That is not a binding ruling that you can't scream fire in a crowded movie theater. The judge is providing an example, and not a very good one. Because if there's a fire in a crowded movie theater, you should absolutely let people know that there's a fire in a crowded movie theater. That's something you should do, even though you have no duty to do so. Like, you're justified in doing that. The implication, of course, in the ruling is that the screaming fire in a crowded movie theater where there isn't one would cause a mass panic and could cause people to be injured. But this isn't actually a carte blanche statement, and it is not applicable to these facts at all. Here, these people had lots of reasons to believe that their daughter had coronavirus and was in contact with other people who may also be carriers of a virus out in contact with even more people, and is trying to warn them. So there you go. But even if she wasn't, you're not in a crowded theater. You're on Instagram. Big difference. Amia wishes to continue to post about her experiences with COVID and her recovery to address microstatements about her, but is afraid to do so. Then we get into the cause of action, violation of the First and 14th Amendments. Again, we're going to skip most of this stuff and get to just the relevant stuff here. Marquette County's disorderly conduct ordinance. So this is what the sheriff said. We're going to ticket you and arrest you based on this. Here's what the ordinance says. It's identical to the state statute. It prohibits violent, abusive, indecent, profane, boisterous, unreasonably loud, or otherwise disorderly conduct under circumstances in which the conduct tends to cause or provoke a disturbance. An Instagram post is really hard to be violent, abusive, indecent, profane, boisterous, unreasonably loud, or otherwise disorderly. These are disorderly conduct tends to involve conduct that is presently accessible by other people, by third persons, right? You getting into a fist fight with someone is conduct that is violent. And if that violent conduct would provoke a disturbance, like you're not in a fist fight in a boxing ring where the fist fight makes sense, but you're in a fist fight in like a toy aisle at Target, right? And you're wailing on someone and they're hitting you back. That's disturbing conduct. So even if neither of you is guilty of assault because it's some mutual sort of thing, you may be disturbing the people around you who have children and now have to deal with grown adults fighting in an aisle over a toy or something. That's what disorderly conduct is about. Or it's about someone who's drunk to the point where their drunken behavior at a daycare, like where they're falling around, causes a disturbance amongst the children or the staff or something like that. This is disorderly conduct. Posting an Instagram post about an ongoing public discussion is really, really, really difficult to be disorderly in any way under the law. So they go on to say, Amaya's Instagram posts about her experience in the hospital were in no way violent, abusive, indecent, profane, boisterous, or unreasonably loud, nor could they reasonably characterize as disorderly conduct tending to cause or provoke a disturbance. And they further say, even if it was, the Wisconsin Supreme Court has squarely held that the disorderly conduct statute may not be applied to First Amendment protected speech. And guess what? lying about yourself when you're not trying to induce or defraud someone is actually protected speech. You can say, I have coronavirus right now. And as long as you're not trying to cause something to happen to someone else that would cause them injury, you're not trying to threaten them like, I have coronavirus in their face, that you could just say, I have coronavirus, I was in the hospital. You can do that. There's nothing wrong. Even if that's a lie, that's just how it goes. That's how protected speech works. And you can't lie about someone else having coronavirus because that could be defamatory. That might not be protected speech. I shouldn't say you can't. You might not be able to. Very fact-intensive questions here. Protected speech is very, very broad, especially when you're lying about yourself and you're not trying to get something from someone else. If she's not inducing people to send her money, she's not setting up a GoFundMe. She's just saying, hey, y'all, can't see you because I got the coof. That's it. It doesn't harm anybody. All right. So the lawsuit has been filed. Now, this is being taken up by the Wisconsin Institute for Law and something. W-I-L-L. I don't remember, but they're taking up the case on behalf of this person in defense of speech. So here's her discharge instructions. You can see that she's got acute upper respiratory infection, unspecified, upper respiratory infection, adult. And then they gave her some, albuterol, that's a nebulizer, breathing thing, and then nothing else. And then gave her some medications that she can take, acetaminophen, stuff like that. So then here we have the work release form that they also provided. So Angela Cohoun, who is I believe the mother of Amaya, and they had patient was employees, child, and others. So this is for Angela to take back to provide to her employer. Hey, I got a quarantine. Amaya Cohoun has symptoms consistent with COVID-19. So this is what they're basing it on. Her Instagram posts are here. I'm not going to go through the whole police department. Again, we have a couple of selected things that are really, really important. And this is the responding sergeant. He says, eventually I did advise Richard that if they were not willing to take the post down, and there would be the possibility of a county ordinance disorderly conduct of being arrested for disorderly conduct due to the fact that they are causing a disturbance by posting that their daughter was positive for COVID-19, and the other parents whose children were in contact with Amaya were now becoming upset over the post. People becoming upset over your post is not disorderly conduct. It just ain't. It ain't. I don't know how else to say it in a more lawyerly way. It ain't. That ain't it, bro. Not at all. You cannot do that. People can be upset if you're threatening to kill people. That could maybe be disorderly conduct, because that's not protected speech, like a threat of violence. It's a threat of violence. I want to do one more thing here. Here's two. Here's the demand letter. They could have avoided all of this simply with this demand. Confirm in writing that Amaya and the Cohouns may freely exercise their First Amendment rights on social media, including reporting the posts reposting the posts they were told to remove, and that you and your staff will not cite them for disorderly conduct or any other crime, arrest or jail them, or threaten any of the above for exercising their First Amendment rights. And then issue a public written apology to the Cohouns for your actions in this matter. That's it. That's all they had to do. Now they're going to take taxpayer dollars to the tune of $250,000, maybe $500,000, depending on damages, could be more, to fight this. And all they had to do is say, yeah, you can exercise your First Amendment rights on Instagram and we won't arrest you for exercising your First Amendment rights. And we're sorry for the confusion over this. Just we didn't want to cause a panic. That's it. That's it. Literally, that's all they had to do. Nope, won't do it. Won't do it. Now let's check out some emails. These are a couple lines from the attorney for the sheriff. Oh boy. Oh boy. So frankly, while I don't look forward to litigation in any case, certainly not in this one, because I think litigation brought by your clients in this case would lack any merit. There was no arrest, no prosecution, and frankly, this seems an awful lot like the 2020 version of Screaming Fire in a crowded movie theater, which, as you know, could be subject to criminal prosecution under existing precedent. That would be that'd be a pretty narrow ruling. You'd have to have a specific fact set to get criminal prosecution under the existing precedent. But you know, this is a bad recitation of the law. And this is a bad assessment of the case. So here's their response. There certainly will not be an apology, and generally speaking, we think it is inappropriate for the sheriff to comment on hypothetical future issues. So that's where the parties stand right now. There's a bunch of emails and stuff. This is all in the filing. You know, there's not much more that needs to be gone through on this short-ish video. But I wanted to bring this case to y'all's attention. This is what happens. They can't do this to you. They can't silence you. This is the again, I know I'm ringing the freedom bell here, but governments don't have the right to prevent you from engaging in public debate about a public health concern. They can't. You have a First Amendment right to do that. You have a First Amendment right to be wrong. You have a First Amendment right to lie. So as long as you're not trying to induce something fraudulently or lying about someone else to cause them harm, you have a First Amendment right to a whole lot of speech. And they don't get to say it's disorderly conduct just because someone got upset about it. That's the right. If you have a right, but it's never enforced or it's never upheld because someone's upset, then you don't have a right at all. That's their problem. They didn't reach out and try and like threaten someone. They didn't target anybody specifically with the post. There's no evidence of any of that. This is her general statement saying, hey guys, I was in a hospital because I have all the symptoms of COVID-19. Pretty sure I had it. Now I'm getting better. Y'all stay safe. You can do that. And the government can't stop you. And when they do, it matters. Think about what they've done here. Think about what they've done here. These people are trying to tell people that they have contact with, that this girl was just in contact with, that she may actually have the coronavirus. They tried to tell the school didn't listen or didn't respond or whatever. So she posted on Instagram to tell her friends, let them know, hey, I might have had this just in case. What if one of them got sick and didn't get tested? What if their parents went to work? What if they took no precautions? What if they went to go visit their grandmother at an old folks home and wiped out an entire retirement facility? You don't get to stop people from speaking, and the actions of the sheriff put lives at risk. That's all I got for you guys. Stay safe, stay healthy. Check out the show, like and subscribe, all that stuff. Good stuff. Talk to you later. Peace. Peace.